Hello, everyone. Thank you for joining me today to discuss the human resources management responses to the issue of the use of medical marijuana in the workplace. So our agenda, what are we going to discuss today? First of all, we'll talk a little about the legal framework and how it's evolving, followed by your duty as an employer to accommodate requests for the use of medical marijuana, the importance of having a policy and what should be included in that policy, how to respond to requests for accommodation, your right and the responsibility to keep your workplace and your employees safe, and then we'll have some time for live Q&A. This is a topic that inspires strong opinions as well as some expected jokes and innuendo, usually from people who are unaware of the distinctions between medical and recreational marijuana. Even quasi-scholarly material has relied heavily on puns like vaporizing the stigma and making the new policy a high priority. So all of that contributes to marketing, webinars, and other educational material, and likely makes the topic a little more relatable, but we shouldn't make light of the implications on HR in the workplace. So some discussion on the legal framework here. Marijuana has been legal for medical purposes, i.e. medical use, since 2001. Since 2014, it's no longer required that a user have a license from Health Canada to use it. Patients still, of course, need the appropriate documentation from their doctor or healthcare practitioner. The use of marijuana for recreational purposes is expected to be legal in mid-2018. Medical marijuana is prescribed and used to treat the symptoms of a myriad of diseases and conditions, including cancer, multiple sclerosis, chronic pain, sleeping disorders, severe arthritis, etc. It is effective. 84% of patients prescribed medical marijuana say that they've experienced significantly reduced symptoms. This, of course, allows them to continue to work or work more normally than before. The use is predicted to grow over the next decade. Health Canada anticipates that users could grow to close to 500,000 in the next 10 years. Who's using medical marijuana? 30% of the users are between the ages of 25 and 34, but almost 50% are over age 35. So as an employer, what is your duty to accommodate a request from an employee to use medical marijuana? The same principles apply to the use of any other prescribed drug. The tricky thing, of course, is that you're unlikely to know that someone is required to use most other drugs, even if they're claimed through your company drug plan, due to privacy issues. So if an employee advises you that he has the required documentation to use this prescribed drug to address a disability, you are required to accommodate the request. However, you have both the right and the responsibility to ensure that you have the appropriate documentation that the use of this prescribed drug is required, and also how the use of it may impact on the individual's performance. Just as important as your responsibility to the individual presenting the request for accommodation is your responsibility to your other workers to provide them with a safe workplace. The individual requesting accommodation does not have the right to be impaired at work, and his coworkers have the right not to have their safety jeopardized if the employee is in a safety-sensitive position. As an employer, we also have the right to be reassured that the intellectual judgment of the employee will not be impaired as a result of the use of this prescribed drug. So assuming you have the appropriate documentation, and we're going to come back a little bit to how we respond to requests for accommodation, assuming you have this documentation, you are required to accommodate. You are, however, in all respects, not required to accommodate a disability to the point of undue hardship to your business. There are three factors that are weighed in the consideration of undue hardship. First of all, cost to the employer. What would the cost of accommodating the disability of the employee be? Would this cost be prohibitive to the employer and your business? Secondly, outside funding. If cost is an obstacle, is there a way to mitigate that with outside grants or funding? And finally, the health and safety concern. If accommodating would present a health and safety concern, either to the employee himself or to others, it might be determined that it would present an undue hardship to the employer. One way that you could be required to accommodate is to actually support a leave for the employee while he's undergoing treatment. Generally, it's pretty hard to prove undue hardship. So moving to policy making. So I have to take a small aside and do a little commercial for having policies in place. Some policies, like harassment for instance, are essentially required for most employers. Small and medium-sized businesses tend to not put as high a value on having lots of policies and structure in place because no one wants to get all bureaucratic. But having a set of policies as guiding principles is a really good management strategy. It makes making business decisions regarding people more efficient, and consistency is always good in terms of people management, both in terms of encouraging good performance and risk management. So that's the ounce of prevention. Your policy in this regard should be crafted in consultation with your safety rep or your joint health and safety committee. Remember, if you have 6 employees or more, you do need to have a health and safety rep. If you have more than 20 employees, you need a joint health and safety committee. You should also review any policies that you have concerning alcohol and drug use at work. Smoking marijuana recreationally at lunch needs to be treated the same as having a beer at lunch. How will you deal with that? There is no right for anyone to be impaired at work, no matter the substance. Your policy always needs to specifically define impairment and specifically define fitness for duty. Employers always have the right to request documentation that their employees are fit for work. There need to be specific disciplinary measures set out for breaching policies in either the recreational or medical use of marijuana. So how do you respond to requests for accommodation? If an employee advises you that he's been prescribed medical marijuana for some condition that he's afflicted with, you should ensure that you request the appropriate documentation from him with the appropriate medical sign-off. If you have any concerns about safety, you should provide a prescription to the employee's medical practitioner so that that practitioner can confirm that during treatment, the employee will be fit for work and able to do his job with any specific accommodations noted, such as scheduled breaks during the day. Smoking in the workplace regulations must be adhered to, and there may be restrictions around your business place as well, and you should check with your building management. Employees are not entitled to be impaired at work. They're not entitled to compromise safety. They're not entitled to smoke in the workplace. And any unexcused absences should be treated in the same way that any other inexcused absences would be treated in terms of your absenteeism policies. The employee is entitled to suitable accommodated work, privacy, and dignity. So it bears repeating, and I know I have repeated it several times, that you have the right and responsibility to keep your workplace safe. There have been a number of cases in this regard, however. One was Calgary versus CUPE, the Canadian Union of Public Employees, 2015. In this case, the employee drove a grader on city streets. He had a back injury and was prescribed medical marijuana in small amounts before he went to bed at night in order to assist in sleeping. The employer maintained that he could no longer occupy such a safety-sensitive position as driving a public vehicle on city streets. The employee grieved this decision, and an arbitration board found there was no evidence of either substance abuse or impairment at work, so he was reinstated. So what about intellectual impairment? Well, it appears that regular and contained use should have little impact on functioning. It's important for employers to request the same okay from medical professionals in terms of fitness for work. What about drug testing? So in Ontario, there must be a bona fide occupational requirement for workplace and personal safety in order to justify drug testing. The purpose of drug testing must be to measure impairment, not to investigate moral values. There must be justification for regular and/or post-incident testing. HR issues must be considered at all times, since disability, including addiction, is a protected ground under the Ontario Human Rights Act. So in conclusion, this can be a very tricky situation, but it's made more tricky by the stigma and the lack of knowledge surrounding this particular issue. The most important points to remember are, look at your policies. Look at your existing policies with respect to the use of alcohol in the workplace, and definitely create a use of medical marijuana policy. Focus on accommodation and safety issues. Be sure that you get all the documentation that will make you feel comfortable and that will make your other employees feel comfortable, but always be cognizant of privacy and the requirement to support your employees as they deal with challenges in their lives. We're now ready for live Q&A.
It's nice to have everybody by today. I'm not sure if you're all in Toronto, but if you're in Toronto, it's a lot nicer to be inside today listening to a webinar on anything rather than being out there. I've had a couple of questions come in already, and I'm happy to take them. It's actually interesting. The first question really underscores the issue that there are two different issues here that we're dealing with. We're dealing with the use of medical marijuana as a prescribed drug and human resources accommodation thereof. And then we're also thinking ahead to, as HR people and as business owners, what it means for sort of social policies once the middle of next year comes and the use of marijuana for recreational purposes becomes legal. So the question was essentially, if we are at a firm party and we have some drinks, once this becomes legal, how should we handle the use of people going outside for not just a cigarette, but, possibly the use of some recreational marijuana? Well, I guess, again, the issue is they're not the same issue in terms of the medical issue, but the same sorts of policies that you should have in place as it relates to behavior surrounding firm social events should apply. And so, you have the responsibility to ensure that your people leave a social event safe. Even though you aren't supplying, presumably, the marijuana, you still have to make sure that you are providing a safe environment. They are also responsible. They are representing your organization with their conduct during and around the social situation. So you have a right to make sure that you set out those kinds of behavioral expectations, and the same kinds of expectations that you set with respect to intoxication in any other way at social events should apply. So again, important to remember though that the two issues are not, they are related obviously because of the common factor of marijuana, but they are to be handled somewhat differently in terms of HR approaches. Another question that I've received is, will our drug plan cover this? So that was a good question, and in fact, the answer truly is, at this point, no. Under drug plans, prescriptions need to have what is called a DIN, which is a drug information identification number. And as it stands right now, there's no such DIN associated with medical marijuana prescription. That may very well change. And, there are also issues with respect to whether or not you are potentially there's a discrimination issue that we are providing some prescription drugs and not others. I do anticipate that this is going to be an area that there's going to be a lot of legal activity and case law and investigation over the next little while. But as it stands right now, this isn't a drug plan issue. I guess a related question to that was, would we be obligated as an employer to pay for this? And I think the answer to that is no. Okay, another question with respect to policy making. I alluded or I mentioned in the presentation that we, in addition to having a policy on medical marijuana, we also need to make sure that we have a policy on alcohol and illegal drugs separate and apart from that. So the question was, what are the kinds of things that should be included in that policy? So the kinds of things that you should be included is sort of the expectation that employees are not intoxicated under any substance while they are at work. that they are remained to be fit for work in all ways, so they shouldn't be impaired by anything. That attending at work impaired or becoming impaired during the work day is potentially a human resources performance management issue. Your policy should set out what the consequences are if that behavior is engaged in and if it continues. But the other important factor here, though, is to think about addiction as a protected ground under the Ontario Human Rights Act. And so there should be an indication in your policies that any employees who suspect that they have some sort of a dependency or an addiction that should be encouraged to seek advice, and that if you end up with this kind of situation, that you need to be very careful with respect to accommodating the fact that the individual has a disability, as opposed to treating it as, purely bad behavior, if you will, within the workplace. So I don't see any other questions at this stage. It's a fairly complex situation. On the one hand, it's quite simple. On the other, it's made more complex with the ongoing stigma and, frankly, lack of understanding as to what the differences are between recreational, if you will, or medical marijuana. It's also, I think, made a little trickier by the fact that the individuals who are in charge in many organizations are still of, I would suggest, my generation, which as my kids mentioned to me when I was doing this research, Mom, what do you know about weed? So, I know whatever I can research on the internet. I'm smiling now. If you were here in person, you'd see. I think, though, that there is a stigma or a misunderstanding or a lack of understanding in terms of the generations that are still generally in charge in our businesses. And we will have to do some learning and have to amend our thinking a little as it relates to the use of marijuana, both medically and recreationally in our workplaces. So happy to answer any other further questions by email or by telephone. You've got my contact information. So I wish you all a pleasant rest of the day. Thanks so much for listening in. Bye for now.